Welcome once again to Lehto's Law. Here's Steve Lehto.
There are circumstances in which if someone wrongs you, you might be forced to arbitrate your claim against them instead of filing a lawsuit. It often arises if you have a relationship with somebody, especially a contractual one. So, you sign up for a service and the service goes haywire and you'd like to sue them. And then you read the agreement that you have with them. It says, oh, by the way, you can't sue us. If you have a problem with us, you have to arbitrate the claim. And in many states, arbitration clauses like that are enforceable. The thinking is that arbitration is simply a different venue, but you can still have the same claims heard. But here's the problem. Arbitration is often more costly, and it's also just a venue being chosen by the person you're trying to sue. And, if I get to pick the playing field and the rules, I'll often win the game. So some big companies have used arbitration to kind of avoid responsibilities. And so an interesting twist has occurred with Amazon. Ars Technica reports that several people sent it to me. Thanks a lot. Tim DeChant wrote it. After 75,000 arbitration demands, Amazon now lets you sue them. They got 75,000 arbitration demands. Some IT-savvy law firms have swamped the retailer with arbitration cases. So Amazon has quietly changed its terms of use last month, dropping the forced arbitration clause. Now people can sue the company individually or in a class action. And that's often what they're trying to do. They'll often put a thing in there that says, if you have a claim against us, you've got to arbitrate it. No, by the way, you cannot bring a class action in arbitration. Therefore, class actions go out the window. So when you hear about these wacky cases where some company rips off a lot of people for a little bit each, well, who's going to file an arbitration claim over a couple bucks? But if 1 million people get ripped off for a couple bucks, you can see the problem. So the change apparently was brought about by a surge in arbitration demands over revelations that Amazon's Echo devices were sometimes recording and saving conversations without consent, including those involving children. Those recordings allegedly ran afoul of laws in several states that require consent before recording and data collection. 2 state laws, the Illinois Biometrics Information Privacy Act and California's Information Privacy Act, have been key drivers of complaints against Amazon. Lawyers have filed class action suits on the grounds that Amazon's Echo recordings violated both consent laws and biometric laws, since some recordings were used to develop voice prints to identify individual users in a household. Amazon's attorneys have successfully argued on several occasions that those cases should be removed from court and sent to arbitration for resolution. So you'd think this is a win, right? Echo users have now brought more than 75,000 arbitration demands against the company, according to a Wall Street Journal report, because Amazon's previous terms said that the company would pay for arbitration filing fees. The retail giant was now on the hook for tens of millions of dollars before a single case was heard, so they've decided to change their strategy on this. And that's one of the things you have to look at. If you sign a contract with somebody, or you're about to, and it has an arbitration provision in it, look to see who pays for it. Because I've seen them before where it says, you agree to arbitrate claims with us, and we'll pay for the arbitration. Which makes you wonder, you get to play a game with us, but we get to hire the referees. But also, I've seen it before where it says, no, we'll split the cost. And then it'll say, we're going to use this arbitration company over here that's really expensive. And it can cost more to arbitrate that way than to go through court, believe it or not. So the idea that we're doing this for judicial efficiency is not really what's going on there. So what happened here was Amazon put in their agreement that said, you got to arbitrate claims with us, but don't worry, we'll pay for the filing fees. We'll pay that cost. So 75,000 people filed arbitration claims. And if you do the math on how many, arbitration claims times how much it costs per claim, suddenly it is into the tens of millions of dollars. So over the last decade or so, companies have increasingly embraced arbitration in their contracts. Companies typically expect that only a small fraction of customers who would otherwise qualify for class action status will follow through with arbitration demands. The companies pay arbitration fees under the assumption that those fees will be significantly lower than defending against lawsuits or paying settlements and judgments. And again, it's all math, and sometimes it works, sometimes it doesn't. In 2018, the U.S. Supreme Court reinforced the power of arbitration clauses by allowing companies to force employees into arbitration over wage theft and other work-related violations. So again, another arena where you might see an arbitration provision is in an employment contract. You get hired to work someplace, say, oh, here, sign this. And it's going to have an arbitration provision in there. And these things pop up all over the place. Now, the Supreme Court decision was 5-4, but it allows companies to sidestep potentially costly individual and group litigation in favor of cheaper, though frequently less transparent arbitration. And the reason they say less transparent is that it'll often say, you agree to arbitrate claims with us using this forum. And you look at it and go, what is this? And oftentimes it's a website. You go to that website and it'll say, here's how this commercial arbitration is going to work. They have their own rules. Here's the costs. And if you've agreed to split the costs, you might discover the filing fee is several $1,000s. And I've spoken to people before who signed arbitration agreements on, like, say, the purchase of a recreational vehicle. And simply to initiate the arbitration is going to cost a couple $1,000s. Where if you're hiring an attorney and they're doing it on a contingency, and all you got to do is pay the filing fee for the lawsuit, it's a couple $100. Big difference there. Big difference. As a result of this decision, others that came before it, arbitration agreements have spread like wildfire across a range of industries. So it'll pop up on your cell phone contract, for instance. It might be the only way you can get a cell phone, actually, to work. T-Mobile, for instance, includes arbitration as the default in its contract, though customers can opt out. Apple's credit card also requires arbitration. Again, you can opt out, but it's there. Most people don't know about it. Online home goods retailer Wayfair includes an arbitration clause with every purchase, as one customer discovered when a headboard he bought on the site arrived with bed bugs. And Google famously pursued engineer Anthony Lewandowski into arbitration for allegedly downloading confidential files before taking a job at Uber. That case resulted in the arbitration board awarding Google $179 million. The arbitration agreement was a part of Lewandowski's employment contract. Google ended arbitration requirements for employees in early 2019, allowing both new and existing employees to sue the company directly and in class action lawsuits. Now, what seems to have turned the tide against arbitration in smaller, consumer-oriented cases is the new trend in the legal profession. Tech-savvy lawyers have begun using digital marketing tools to recruit and sign up thousands and even tens of thousands of customers to participate in arbitration. One firm has reportedly built its own IT infrastructure to handle client recruitment and communications, where other small firms outsource their IT operations. The Chicago-based firm even employs a full-time director of IT and analytics. In an early case, that firm recruited more than 5,000 DoorDash drivers who claimed they were improperly classified as contractors. When the food delivery company found itself faced with millions of dollars in arbitration fees, it attempted to push the drivers into filing a class action lawsuit. So there the company's actually saying, we'd rather have you file a class action than do what you're doing. A U.S. District Judge instead forced DoorDash to arbitrate each claim, costing the company nearly $10 million before the cases were decided. In November, DoorDash individually settled claims brought by 35,000 drivers for a total of $85 million. No doubt, DoorDash never expected that so many would actually seek arbitration. Instead, in irony upon irony, DoorDash now wishes to resort to a class-wide lawsuit, the very device it denied to its workers to avoid its duty to arbitrate. This hypocrisy will not be blessed. And again, that is a judge writing. Interesting thing is that class action lawsuits, although many people are skeptical of them because the results we see are often de minimis, as we say, everybody in the class gets a coupon for a set of floor mats, and the attorneys get $19 million in fees, and the problem, whatever it was, is not resolved. That often happens, it seems, with class actions. But class action lawsuits, in theory, are a decent idea. So in other words, there's several thousand people with identical claims against one defendant. Several thousand people can file lawsuits against that one defendant and clog up the courts. Or one person can stand up and go, let me be the class rep. I'll represent all these people and I'll do a good job and we'll see what we can do for the entire class. And that resolves thousands of claims in one action. Why wouldn't that be more efficient? So interestingly, when DoorDash puts an arbitration clause in their agreement says, all of you have got to arbitrate with us if you've got problems, they're hoping the average person is not going to do it. And one of the things that a lot of the arbitration clauses are pointed at is that people who are putting them in the contracts are hoping that an arbitration provision will scare off not just the person who signed the contract, but that it'll scare off an attorney. And the reason it would scare off an attorney, to give you an example, is that I do lemon law. I handle cases involving defective automobiles. But I used to, in the old days, handle a lot of RV cases. I don't anymore, but I used to handle a lot of RV cases. And in an RV case, to get your attorney fees paid is more difficult. It's possible, but difficult. And the reason is there's a law called the Magnuson-Moss Warranty Act that covers RVs and says if an RV can't be repaired in a reasonable number of repair attempts, then the manufacturer's got to either buy it back or swap it out for a new one. Now, the question is, what is reasonable for an RV? Well, it depends on the problem, how many times it's been in, and the RV industry will tell you that no matter what the number is, it's reasonable. 14 repair attempts, that's normal. 15, that's normal. 27, that's normal. They're just numbers, right? All numbers are normal. And so I've had the situation, and I know other attorneys who have as well, who've gone into court on a case involving the Magnuson-Moss Warranty Act, because it doesn't have a number in it that says, this number is reasonable, this number is not reasonable. You go into court, and a judge says, well, wait a second, to the defendant, are you guys willing to fix this vehicle one more time? You are? Okay. Plaintiff, why don't you let him fix it one more time? Well, Your Honor, we've had it for 2 years. The warranty's about to expire. They've already tried fixing it 13 times. But they're willing to fix it. Just let them fix it one more time. And so because of these weird results that you can get from that, these cases are shaky to begin with, despite the fact that the vehicles are usually junk. However, if you go into an arbitration setting, it's even worse. Because arbitrators, number one, they're not judges. I've seen some former judges who do arbitrate as like a part-time job on the side, but quite often they're simply people who've taken a class on arbitration that was given by the company that runs the arbitration process, and they've been hired now to arbitrate these cases, and they know that the people who are causing them to be hired are the defendants, and rulings often go in favor of the defendants. And here's the thing. If I win a case in court under the Magnuson-Moss Warranty Act, it says specifically I get my attorney fees and court costs paid. However, if I win an arbitration, an arbitrator can go, you know something? Well, you didn't have to go to court. You just arbitrated. You get no fees. And you can't appeal an arbitration decision. So I know attorneys who just, as a matter of course, will not take these cases unless the plaintiff agrees to put up a few $1,000s to cover the arbitration costs, but also to cover the attorney fees. And anybody who works has got to get paid to make it worth their while. So arbitration will scare off a lot of attorneys who don't want to get involved because they know they're not going to get paid or they don't think they're going to get paid. And also it's going to scare off a lot of just people, civilians, consumers who look at it and go, what's this process? I mean, as scary and daunting as courts are, many people are familiar with the courtroom. They know what it looks like. They may have even been to a court on one occasion or another. What's an arbitration look like? And I've had arbitrations that took place in conference rooms, in office buildings, and I've had, over here and over there. And arbitrations, each one looks different than the other. And so you don't know what you're going to get. So I think that the arbitrations are designed to scare off the consumers, to scare off the attorneys, and in some settings it works. But the funny part is that some of these companies, to make it look more friendly, say, well, look, we'll pay the arbitration costs. And now how can you complain? We're not going to complain. We're just going to file 75,000 arbitration claims and see what happens. So I'm actually surprised that some of these companies don't instead try, you can arbitrate, we just won't pay the filing fee. But they know how bad that would look from a consumer standpoint. So Ars Technica published this article. It's fabulous, but Tim DeChant, Nathan, Gary, Trocon, and Keith all sent it to me. Thanks a lot. After 75,000 Echo arbitration demands, Amazon will now let you sue them. Interesting turn of events. Questions or comments, put them below. I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Sometimes the questions are complicated and the answers are so simple.